After the government's decision to tax caramel popcorn and salted popcorn at the differential rates of 5% and 18%, which was announced in December last year, a similar question has popped up before the Bombay High Court in a case concerning donuts. Should donuts be taxed at 5% or 18%? How much are they currently taxed? And why did this question come up before the Bombay High Court in the first place? Hello and welcome to ThePrint. This is Khadija Khan from New Delhi, and today I'm going to tell you about the Bombay High Court's recent order where it said that it would decide if the supply of donuts should be taxed as bakery products, which are liable to a much higher tax rate of 18%, or if they should be taxed as restaurant services, which are levied with only 5% tax. Now, suppose that the base price of an average donut is 140 rupees today. If Mad Over Donuts wins this case, the average donut would be taxed at only 5% as a service, which means that the consumer would have to pay a total of 147 rupees. On the other hand, if the tax authorities win this case, the average 140 rupee donut will be taxed at 18%, which would mean that the consumer must pay 165 rupees for the price of an average donut. The issue arose in August last year when the Directorate General of Goods and Service Tax Intelligence, or the DGGI, slapped Himesh Foods, which is commonly known as Mad Over Donuts, with a notice asking them to pay 100 crores in fines and taxes for misclassifying their product as a restaurant service and not as a bakery product, and thereby having to pay lesser tax on it. Other donut chains slapped with similar notices were Krispy Kreme and Dunkin' Donuts, amongst others. This is what led the donut chain Mad Over Donuts to approach the Bombay High Court with its plea, where it sought a clarification on whether the supply of donuts falls under the category of restaurant services or if it should be deemed as a bakery product subject to a separate tax treatment under the GST framework. Now, what is Mad Over Donuts' case? In its plea, Mad Over Donuts argued that the supply of donuts is a service since it falls under the composite or mixed supply of goods and services, a concept which is squarely covered in the Schedule 2 to the CGST Act, Entry 6. Now, Entry 6 says that a composite or mixed supply of goods and services shall be treated as a supply of services. Examples of this include work contracts and the supply of edible goods like food, including takeaway. Another example could be if you want to buy a house in, say, Defense Colony. The combination of the service of constructing the house along with the goods like construction materials, including bricks, tiles, etc., make this a composite service. In conclusion, the donut chain's argument is that since the supply of donuts is a combination of goods and services, it is a composite supply and should be classified as a service. Relying on a GST rate notification issued by the Ministry of Finance in 2021, which defined restaurant services to include food supplied at restaurants, eating joints, messes, and canteens, whether for consumption on the premises or as takeaway. The donut company said that a government-issued circular supports this interpretation by confirming that takeaway services should be classified as services and taxed at 5%. All eyes are on the Bombay High Court now as it hears this case again on March 24th. Is this the first time that the courts will decide such a case? Although this will be the very first time that an Indian court decides whether to tax donuts as bakery products or as restaurant services, there have been similar tax cases in the last few years. Notable amongst these was the Kerala High Court's April 2, 2024 ruling, where a two-judge bench stayed or paused the operation of a ruling passed by the Kerala Authority for Advanced Ruling, which held that the Modern Foods classic Malabar Parotha and the whole wheat Malabar Parotha were eligible for 18% GST under the rate notification issued under the CGST Act 2017. Another example is the differential tax treatment accorded to ready-to-eat or normal popcorn, pre-packaged popcorn and caramel popcorn, all of which are taxed at varying rates of 5%, 12% and 18% respectively. And that brings us to the end of today's segment. For more legal updates, keep watching The Print.